to all the young lawyers out there, this is a little hack that I propose you try sometimes in a court of law if your senior permits you. When I started out my practice of law, I had a senior who had 20 to 40 matters per day. And on a lot of those occasions, the senior could not do more than, say, 5 or 10 of those matters himself, and he would have to delegate a lot of the work to his juniors. I was one of those juniors, and each junior in the chamber of this senior lawyer had the responsibility, had the duty, and had the liberty to go and argue matters on their own if they were not very, very important, and if something not very, very important was needed to be done on that particular date. So this is what I used to do, despite A, not having my name on the wakalatnama, which is a big problem sometimes you will also face, and B, I, despite being afraid that I might lose the case of the senior lawyer and might face reprimand. This little hack that I found out worked brilliantly for me. It was not foolproof. Maybe 1 out of 100 times I did suffer the consequences. But I wanted to make this video just because very, very recently, when I was arguing a matter, the lawyer from the other side, his junior came, tried to pull off this same stunt, but did not effectively do one thing because of which he lost the case to me. Now, what I used to do back in the day was I would go to the judge and start off my submissions by saying this: My lord, the main arguing counsel is not available today, but if my lord permits, I can perhaps try to assist the court with furthering the proceeding uh, in a speedy manner. And then I would go on and make my submission, because of which, if the judge had to dismiss my application or to allow the application of the other side, basically, if the judge were to decide against me, the judge would say, all right, I don't agree with you, call your senior. And then the judge would proceed to call the senior. The senior would still try to convince the judge. And even if then the judge is not convinced, then in the presence of the senior, with no harm being done, at least to whatever extent that can be done by a junior lawyer, with no harm being done, the order is passed. On the other side, though, if the judge agrees with you, in that situation, the court passes relevant orders agreeing with you and in your favor. So you get all the benefits of arguing a matter, but you don't suffer any of the drawbacks. In contrast, what happened just yesterday was that the junior counsel, what had happened was the opposite party had filed an application in the court just a week prior, and we were also given an advance notice of the same. Now, usually what happens is, if the lawyer takes it in an easygoing manner, the lawyer for the other side, that is me, yesterday comes to the court, says, all right, my lord, I have received a copy of the application. I seek my time to file my reply, and the matter may be fixed for the next date of hearing for arguments on these applications filed by the opposite side. Instead, what I did was, I straightaway reached the court with my written submissions, with my judgments opposing the application, and I stood there and I said, I am here ready to argue my application. Now here, instead of starting out with saying that the senior arguing counsel is not available, please adjourn the matter, the junior counsel, or pulling off the stunt that I used to pull off, the junior counsel says, my lord, these are our applications, this is what they say. Now, when he mentioned this, I started proceeding with my arguments on why these applications should be dismissed at the very outset. 5 minutes into the arguments, when the judge also started agreeing with me, then he proceeds to say, but my lord, let them file a reply. My lord may fix the matter for arguments. And at that point of time, I say, no. You have started your arguments. I am here. I don't wish to file my reply. I am here ready to give my oral submissions. I'm giving my judgments. I'm giving my written submissions. I don't need any more time. At that point of time, the junior lawyer says, my lord, the main counsel is not available. Please fix the matter for another date. And again, I oppose and I say, you should have mentioned it at the very start. 5 minutes into arguments, now you have wasted judicial time, the time of the court, and now you cannot say my senior counsel is not available. And the court also agreed with me, and because of which the applications got dismissed. Little distinction. You start out by telling the judge the senior counsel is not available. In that situation, If the judge says I don't want to listen to this, if the opposite party does not wish to vehemently oppose the application, he will simply say, all right, let them have it. Even if the opposite party says, no, I want the application to be decided today, even then the judge will grant you that kind of discretion, because you have come for the first time or second time or whatever it is before the judge and sought a small adjournment. So in the eyes of the judge, you've done nothing wrong. And if the judge is one of those who is inclined to hear the matter, if you say this at the very outset, 99 out of 100 times the judge will say, all right, I am not convinced, please call your senior. Or if the judge agrees with you, the judge will say, all right, I am passing the necessary orders in your favor. This is a small hack. Use it with utmost caution. I do not accept any responsibility for what happens. However, good or bad, whatever happens, if you do use this strategy, do let me know in the comments. And since I am talking about you posting in the comments, I never say please subscribe to the channel. Here I am, as you know, when I remember to ask you to please subscribe to this channel for more legal content. Thank you.